e-discovery. And that's a very, it's a legal technical term that usually you're probably thinking to yourself, that's why we pay the attorneys to know about this stuff. But we thought it would be a good topic and maybe an interesting topic to talk about because you guys are part of the litigation process once you're involved, and to have an idea of what the courts and the rules say about this topic, to know how you might be treated if you do find yourself in litigation, it might be sort of helpful and help you prevent any missteps or problems if you do find yourself in a lawsuit. So we're going to kind of go over what e-discovery is, what it means, and at the end we'll talk about some practical tips for boards and directors and managers to keep in mind when it comes to operating an association while you have litigation that's contemplated or pending. So we'll just jump right in. I do want to also note that this topic kind of came to mind based on a podcast that Clint did last year that's on our website. And our podcasts are also available on the iTunes and Apple iTunes and Google Play Music stores. So if you are into podcasts or want to hear about a little bit more information about e-discovery, Clint talked to Jennifer Brandon last year, and she actually was pretty instrumental in the Phoenix area for firms in implementing and growing the e-discovery world. Because if you even think about it, in the past 20 years, how far e-discovery has come and what it's kind of evolved into is kind of a whole new beast, and she's been very instrumental in kind of steering that and implementing it through the courts. So an interesting podcast, kind of a little bit of the background, some of the topics that we'll talk about today, Clint also discusses with Ms. Brandon. So it's kind of interesting if you guys want to check that out. So the first thing we're going to talk about is a little bit of background on litigation and discovery basics. Because when I say discovery, you might be thinking to yourself, what is she talking about? And I'm not just talking about discovery, the concept of like, we're going to find things out. Discovery is a technical term that is just basically kind of, maybe makes sense, but it's just the process of exchanging information between the sides of a lawsuit. So discovery happens in almost every lawsuit, and it's just an opportunity for each side to find out what that side has in their possession, whether it's good for their case or bad. Have either of you been involved in any litigation in your course of dealings with associations? No. Okay, lucky for you. You're like, no, and we don't plan to. So
that's why we plan ahead.
That's right, yeah. So that's good. So we're talking about a lawsuit that's been filed, typically, plaintiff versus defendant, but as you probably realize, there can be multiple plaintiffs on one side or multiple defendants on the other side. So when I say parties, I'm talking about anyone that's been named in the lawsuit. So if the association's been named in the lawsuit, from time to time you see individual managers and directors named in the lawsuit. Those are what we call parties to the lawsuit. But there's also non-parties, or if someone witnessed something, or if we want to have like neighbors testify in an enforcement action or whatever, those are non-party participants in the lawsuit. So going back to discovery, there's different types of discovery that the rules of civil procedure allow for. And we're going to talk about the main four today. The first one is depositions, which you might have seen in like TV shows or movies. That's basically where you either have, it's either a party or a non-party being asked oral questions by the other side's attorney. And there's usually a court reporter there taking it down or recording the words now, even is usually how we see it happen, to find out what information that person has and how it's relevant to the issues in the lawsuit. The second type is called interrogatories, which are just written questions that one side sends over to the other side to be answered. So it can be any kind of written question that would lead to any relevant information depending on the type of case. And you just kind of question, fill in your answer, and send them back. The other type is a request for production of documents or things that are relevant to the case. So a request for production is also written down and given to the other side, but instead of answering a question and giving it back, the other side expects you to actually produce copies or the actual thing that they're asking for in their request. So it might be, we want to request to produce all meeting minutes for the last 6 years, or request to produce all receipts related to whatever purchase that the board made related to one issue. It can also include things, so like I always think more in like a criminal context, like request for like your dirty shoes that you wore on the night of whatever date, but it can include like actual tangible things or copies of documents, originals of documents, that kind of thing. And then the last one is called a request for admission, and that is also a written document that's given from the other side, and it requests that the other party either admit or deny the statement that's contained. So it'll say, admit that on July 31st you stole my boat. And so you either admit or deny that. And if you admit it, then it's taken as an admitted fact in the case. And if you deny it, then it's denied, and you state why you're denying it. So that's just kind of a brief overview of the types of discovery. The other thing that's a tool in discovery in litigation is called a subpoena, which you guys probably have also heard of, which is just a writ that's signed by the clerk of the court for whatever county that you're litigating in that is ordering a witness to do something. So either produce documents at a certain time and place. It can be a subpoena to attend a deposition, like we talked about before, or to attend a trial or hearing. And that's a court order, so if that person fails to do whatever the subpoena is requesting, then that person could be held in contempt of court. So when I'm talking about discovery, I do want to also make clear what the rules consider what is included in discovery. Is it everything the association's ever produced and made, and now they have to send it to the owner? Not necessarily. The Arizona rules say parties should exchange any non-privileged matter that is relevant to any party's claim or to a party's defense and proportional to the needs of the case. So they're going to kind of do like a balancing act a little bit and decide what's proportional, but it has to be relevant to either the claims or the defenses in the case. So keep in mind too, though, that not everything that's discoverable is admissible. So there's kind of like this halfway mark. You have to turn over to the other side anything that's relevant, but it need not be admissible at the end of the day in a trial. So that's kind of way down the road over here that we'll figure out later if it's admissible, if it's coming into the court. But to be discoverable, it just needs to be relevant to an issue or claim in the case, which is a pretty broad definition of what sort of things need to be handed over in a lawsuit. The rules also say that you have to include any information or data that's in the party's possession, custody, or control, or any information or data that the party can learn or ascertain or acquire by reasonable investigation. So you can't really stick your head in the sand and say, I think we got everything, but yep, that's it, that's everything. You have to take reasonable steps to make sure, okay, did we check here? Did we check this file? Is there anything relevant from so-and-so? They've been off the board, but they might have something that's related to this lawsuit. And you have to take those reasonable steps to see that you've given everything that might be relevant to your attorney for them to give to the other side. There are certain things that can be excluded from what is discoverable, and that would be obviously anything that's unrelated to the case, considering it has to be relevant to the issues, to the matters at hand. Anything that's privileged, it's like an attorney-client privileged communication, would not need to be necessarily disclosed or discoverable, or anything that's considered work product, which is something that's prepared in anticipation of a lawsuit. So if you have your attorneys, working on steps and communicating with the board because you anticipate that an owner is going to sue, that document or communications may also not be discoverable because it is considered work product. And then there's also anything that is not reasonably accessible due to some sort of burden or undue expense. So if it's, it exists, but it's going to take a lot of time and money potentially to dig through all these files or whatever, or if it's before. I hear this a lot with law firms, is so maybe some documents 10, 12 years old that we think the prior attorney's firm has, but that was before they started scanning their files. So it's in a box somewhere in like one of 40 storage rooms, and they're not labeled. So how are we going to find that 3-page document and all of this? That might be a situation where it's burdensome on the association to have to produce that particular document, but we know it exists, but it's burdensome. So now turning to more particularly e-discovery. So I've talked about a lot of different things, producing documents, emails, communications. E-discovery is just basically what I've been talking about this whole time, is discovery of any data that is involved in a case that is electronic and stored electronically. And it's hard for me to think of an example of something that's not really stored electronically in this day and age. So much of what we do is either saved on our computer, emailed, typewritten, and then mailed. That really loops in e-discovery to be very applicable in almost every case. So it's more like very specifically, e-discovery includes emails, texts, if you text your board, if you text your fellow directors, if you text owners, I'm not sure, that would be potentially a discoverable electronic file. Saving your files to computers, any communication on Snapchat or WhatsApp, messaging apps, instant messaging apps, virtual meetings even if those are recorded on like Zoom or Skype. These types of things are electronic and they would also potentially be discoverable. You might also see reference in our materials to what's called ESI, and ESI just stands for electronically stored information. So that's any data that is generated on a computer or device, like your phone, on your network, on your cloud, on your servers that you have, and stored there. And so when you really think about it, almost every case would involve e-discovery in today's day and age. It's not just for like the big, Apple versus Samsung major cases where there's going to be a lot of technical issues, and it really can become in a simple breach of contract case, in an enforcement case where people are communicating. If it's all happening electronically, that's e-discovery. So we want to bring that to your attention to kind of give you an idea that what every day in just the communications that you have, those could potentially be exhibits in a trial someday. So don't want to scare you, but that's we're going to talk about a little bit about that and the tips at the end of the class. But it really does have kind of a far-reaching impact to your day-to-day operations and to your directors as well. So I want to now talk about the scope of possible discovery for e-discovery. And it's a little bit hard to talk about this in a vacuum without like a test case, but you kind of get an idea of, we need to figure out, if you've been sued, what does the other side have that even is e-discovery? What kind of communications do they use? How are the parties communicating? How are they saving information? In order to do that, one of the tips that Jennifer had on the podcast and what they use is called a custodian questionnaire, which is a little bit like the interrogatories that we talked about earlier. It's just written questions that can help narrow down the scope. So maybe these people, use email and they have business phones and they use instant messaging, but they don't have any, they don't have any files stored in the cloud, and they don't have any video meetings recorded. So that helps us at least have an idea of what's in play. You also want to think about, kind of like I mentioned earlier about proportionality. Both sides need to kind of set the boundaries of what is going to be necessary for whatever issues are in the case, and where this information is stored, and how is the best and most efficient way to go about collecting that. Are people going to hold hands and play nice, or are we going to have to kind of duke it out and get the court and other third parties involved? You also want to think about privileges when you're talking about scope, kind of like I said earlier. But I also want to point out the distinction between company phones and personal phones. Do you guys, as managers, where you are managing currently, do you have a company phone, or is it basically your personal phone is the phone?
I have a personal phone, but I don't get any emails for work on it. The only thing I get would be phone calls that get forwarded from my company phone number to my number. So we try to keep it limited.
Yeah.
I don't text board members or anyone from my phone.
Personal phone.
It's all email or phone call or in our office.
Okay. Are those calls on your personal phone like recorded in any way?
No.
Are they recorded on your company phone? I know we do, but.
Well, since it
on
goes
your, like,
through
actual
there,
office.
it would show a phone number that this phone
That
number dialed in
yeah.
and it got forwarded. That's it.
Okay. I feel like most directors, I mean, it's not like people are handing out cell phones when you get elected to the board. So you're kind of using your phone for, if you're communicating via Gmail with your manager, that's on your Gmail. You have your, communication with your husband on Gmail and your manager on Gmail. So it's all kind of intertwined.
Are you saying we shouldn't be doing emails on our personal phones?
Well, that's the $1,000,000 question, isn't it? I would say to keep it organized, and that's going to be the most important part. In today's day and age, it's so hard to not communicate via email. I think it's what I would probably do if I was on the board is to have a Moscarello HOA@gmail.com, and that's what I give to my manager, and that's what we communicate to kind of avoid that intermingling. It's hard to do otherwise if you're just going to say, hey, manager, you can't email me. Like I don't have an email and I'm not going to be accessible by email. In 2019, that's almost unheard of. Like I don't have any clients that are like, don't email me. So
we just moved all of our board emails to they each got their own email.
I think that's the easiest way to do it.
And that separates them, takes it out of their personal email. So if there is a discovery, they don't have to submit their entire email.
Yes. Or have a third party go in and be like, okay, not the emails about the vacation, but the emails about this enforcement issue and whatever the board was talking about for that.
And
I think it's the easiest way.
I actually just created my non-personal one yesterday, but I can still, I've got 6 email addresses.
Oh yeah, and you can flip through on your phone. Yeah, that's fine. And just say, because in a custodian questionnaire, you'd say, yes, all of our directors have their personal cell phones, but they also have personal email addresses and HOA email addresses. So we know for a fact that they created it in April 2019. This issue came up in July 2019, so any communications would have been on their new HOA specific email, so there's no need to go in reaching into the personal emails, and that I would think 9 times out of 10 would be sufficient for the other side.
But I just did that yesterday,
right.
So I was using my personal one.
Yeah.
So if there were something that would have happened between February and yesterday, then they can actually look through all my personal emails.
Well, they would need
just
to go.
to see if it was relevant.
Yeah, right. They wouldn't need to go.
I had written down that question.
Right, yeah, no, you're right. It's exactly it. They would be able to access your personal email that you've always had. They wouldn't necessarily click on every email just to be like, is this it? Nope, is this it? But they would need to kind of cull through, and there's ways that they would do that. And they would arguably be able to do it.
Yeah. Okay.
So that's kind of something to keep in mind, and I think it sounds like you guys are on the right track. If you don't have a business-specific phone, at least kind of create your own little organizational device, your own separate email that you can keep over here separate. And then the other thing I wanted to mention as far as scope are versions of draft documents. So I don't know if this is true in you guys' offices, but in our office, we go through 2 or 3 drafts before we have our final draft. It's possible for third-party vendors to go back in time and capture different versions of drafts. If you want to say, here's the final contract, this was the final contract, and they want to say, well, yeah, but on version 2, we had it like this, and so they can go back to that version and then see what changes were made between version 2 and version 3. So just because you have a final version, or if that's like a central issue in the case about a prior version, that could potentially come into play in a discovery dispute issue. So that's just something to keep in mind, that those edits and changes to it can be kind of recovered, if you will.
But isn't the final signed one, the legal document?
Yeah, and it's just, if you would ever think of like a situation where they might be like, hey, our copy says 4 months and your copy says 2 months, how did we get here? You know, if there's a very specific fact issue where that might become relevant, Jennifer on the podcast does talk about how that might come into play, where you're like, well, we had this as our final document, how can you go back? And there are ways that they can go back and recapture what changes were made when. So it's kind of interesting. It's very, a little bit technical, but a little above my pay grade. Speaking of, the next thing I wanted to at least touch on, without getting too much into it, is the process of obtaining information in these discovery disputes. I don't know too much about this because I haven't been through this myself yet. But I wanted to at least kind of give you an idea of what happens when the parties do identify what exists in their universe as relevant, but they don't want necessarily me or the board going through their personal emails. What can happen then is to hire a vendor or a third party to go in and get the relevant data. So that third party goes in and images the information. So they'll either copy the drive that we know there's relevant information on, or copy the phone, or go into the email and search for the relevant data that way. I know that Jennifer talks on the podcast about having the what she calls the end user temporarily changing their password so that the third party vendor can go in with that changed password and kind of do, like if this was you, do a search for like homeowner's name or lot 99 and see what comes up, pull that stuff, save that, and then you change your password back. So that there's a way for them to have access and pull out what they need, but to not overburden you and be going through all your personal information, because that's not fair either. So there are ways to do that. There's different search terms that the parties can agree on for the third-party vendor to go in and look for those. And there's ways for them to do that and disregard the personal or unrelated items. Because even if it's your HOA-specific email, not every email in there is going to be related to this lawsuit. It's not like you're only just talking about the one problem person in all of your emails. So they shouldn't, if you can get an agreement that sets the boundaries for that third party, and they'll go in and search for X, Y, Z and leave the rest. So that's a little bit of protection for both managers and directors who need to be involved in something like this. And then, of course, my favorite thing to talk about is cost. As you can imagine, this is not a cheap thing to do. Similar to us, these vendors do what they do on an hourly rate. I kind of looked into it and found that to do like a simple collection of data, it's about $250 to $350 per hour. To do an analysis of that data is more $300 to $600 an hour. Of course, depends on the complexity of the data and how much there is, and how much time it takes. But from everything I read about this topic, that can get pretty expensive pretty quick, depending on how many. So then you do that for times 5 directors. So it can really get pretty expensive. The next thing I want to talk about is preservation of e-discovery or your ESI. A preservation letter is just a written letter but puts the other party or a non-party on notice that the recipient, the party or non-party, has to preserve the ESI for pending or anticipated litigation. Once you get that preservation letter, you are on notice. So your duty really, if it didn't kick in before, which we'll talk about in a little bit, it certainly kicks in now. So you can't, once you get that letter, you can't be like, that's nice, and then start deleting all your emails. That will get you in trouble. And we're going to talk about the trouble that gets you in, or sanctions a little bit later on. Jennifer also talks about on the podcast, in addition to different versions of drafts, deleted emails and deleted texts. And it really is dependent on how long those, like Google or Gmail, saves anything that's been deleted, as to whether that stuff can be recaptured. But from what she was saying, sometimes it can be recaptured, or if it's possible, like if someone was CC'd or BCC'd on an email, to recapture it that way. So someone else completely unrelated, or like an old director might have to be involved now because you deleted your stuff, but John was CC'd on everything. So sorry, John, you're involved now, and we have to go through your stuff too, to try and recapture whatever information that an opposing party thinks or knows exists that hasn't been turned over yet. Sanctions in a discovery dispute are handed out by a judge. So this is kind of where things have really reached their boiling point, and both parties kind of go to the judge and explain to the judge why they can't play nice with each other and what the problem is. If a judge finds that there's really been a major problem, or like a bad actor involved here, which it would include deleting or spoiling any e-discovery, there can be some serious ramifications to that. Both the federal rules and Arizona rules of civil procedure say that deletion or spoliation must be intentional before sanctions are awarded or imposed. And that's very, very specific under the federal rules. And I'll get into some of the Arizona rules without boring you guys too much about what kind of implications and what sort of meet and confers need to happen before that point. But it can get really, really serious if there's really no way to restore or recover what's been lost, especially if the other side can show that you did so intentionally. Because sometimes, things over time get, like if you have your video camera, it doesn't get re-recorded. And so if you don't take steps to preserve that as a matter of fact, and it just so happens, every 2 weeks it gets rewritten, that might not be an intentional thing. So those sanctions might be different than if you're sitting in the corner over here deleting all of your emails because you're about to get sued and you don't want anyone to find out whatever it was. So we'll get into some of that Arizona-specific stuff in a little bit. And then the last thing we'll do is talk about the tips. So there were new rules that came out for us in Arizona in 2018. They kind of workshopped them in 2017. They came into effect in 2018. The major themes are encouraging the parties to work together, preserve all of your stuff, and then changes to sanctions and how you go about getting sanctions for a party that you think was behaving badly and spoiled all of your evidence. It's also just interesting to note that the federal rules changed in 2006 to include e-discovery, like generally. So I just think that's really interesting. 13 years ago, this was all brand new, and lawyers were kind of figuring out how are we dealing with this, what does this mean for the courts, and it's really, like I said before, come a long way in a short period of time, and now there's all these rules in place that help guide attorneys and hopefully parties to figure out what the requirements are for them and what they're going to need, what standards they're going to need to meet in order to not get in trouble with the judge. So the first thing I wanted to note is Rule 16b, which was a change in 2018. Not to e-discovery specifically, but just to all litigation cases, it requires attorneys to do what the rules call meet and confer. And that just means that the attorneys meet and have a discussion about the topics that are listed in that rule, which I didn't list out for you in the slide, but you can definitely look them up. And it just kind of more generally talks about what the relevant documents are, who has relevant data, and where did they keep that relevant data. And now you're also required to discuss how the ESI is going to be produced. This meeting is really meant to figure out, are people going to play nice or are they not? And I think that this rule came about because people would just kind of jump right to the courts and right to the judge, say, Judge, they're doing this and they're doing that, and they're hiding the ball and they're not getting back to us. And I think courts got tired of really having everyone come in front of them, so they're like, nope, you guys need to sit down, and it has to be either on the phone or in person. It can't just be an exchange of emails. Hey, are you gonna send this over? Nope. Okay, well, we're going to the judge. You have to sit down and really try and hold hands and play nice and say, are we going to, exchange this in a kind, cordial manner, or are we going to have to get a third party involved, or how are we going to do it? If the device or the mechanisms are not turned over, you can file what's called a motion to compel with the court and go through it that way. The other rule that came about last year is a big change to Rule 37. Now, Rule 37 kind of takes e-discovery from the very beginning. So the very first thing that's really talked about in Rule 37 as far as e-discovery goes is preservation, which we talked about just a little bit ago, and the duty of parties to preserve ESI. And that rule specifically says a party has a duty to take reasonable steps to preserve relevant ESI that's relevant to that action. And then it also clarifies when the duty starts. So it's pretty common sense, but once the action commences, so if you're the one filing it, the action the day you file it, okay, well here, we have to take steps to preserve our video and don't delete your texts and keep all your emails, and so that starts your duty there. Once the party learns about the action, so every now and then, you don't even know that you've been sued until you've been served. So that once you learn that, you have a duty. Keep that in the back of your mind if you are ever served. Okay, we need to make sure that nothing's being deleted intentionally or otherwise, because now we're on notice, and we've got to that's extra duty on us to make sure that we're not doing anything to spoil any evidence. Or this is kind of the tricky one where it's, what does that mean? Once the party reasonably anticipates that the action is going to commence. So what does reasonably anticipate mean? And luckily, the rule answers that for us, which is very rare. As you guys know, it's never that easy, but they do try to define it. So the rule says when a person knows, or reasonably should know, that it's likely to be a defendant in a specific action. So if someone says, my lawyer's going to file his lawsuit on Thursday, you should reasonably know that you might be a defendant in a lawsuit. I think it happens probably maybe more to us than to you guys, but people, I'll see you in court. Does that put you on notice to be, or should you reasonably know that you're going to be a defendant? I mean, it's pretty broad, vague. We hear that all the time. And 9 times out of 10, we're not in court with those people, and then, in the coming weeks or months. The second thing the rule says is, if a person seriously contemplates commencing an action or taking specific steps to do so. So that kind of approaches it from the other end of, okay, well, I'm pretty sure I'm going to sue Dan over here, and so I can't just be like, I better delete these mean emails that I sent to Dan so that I look better, when I know that I'm going to call an attorney tomorrow and file a lawsuit, hopefully in the next couple of weeks. So I think that is pretty common sense. If you know or have reason to know that you're going to be suing someone or someone's going to be suing you, take the necessary steps to preserve your electronic data. Then the rule also helps you to clarify what are the reasonable steps, because the rule says take reasonable steps to preserve your relevant ESI. So reasonable steps just need to prevent the routine deletion, kind of like I talked about earlier, of electronic informations, or just documents that are destroyed pursuant to a policy, or just as a matter of course, we always destroy, super old documents after 10 years. Well, if you're approaching the 10-year mark and you know you're going to be sued and you're not sure if something's relevant in there, but it might be, you might want to say, hey, let's put a timeout on our typical policy because we know or should know or received a preservation letter or whatever the case may be. When it comes to taking reasonable steps to preserve, the courts will consider a list of factors which is listed in the rules, but to kind of give you guys a flavor of what courts look at, it'll consider so if something's lost and the other party's kind of disputing, we'll say, they don't have that anymore and that hurts our case, the court will really look to the information's probative value, which means how much information can come from that specific document. It'll look at the burdens and costs of preservation balanced with the issues at stake in the lawsuit. How accessible is that information, the difficulty in preserving the information, and whether the loss of that information was based on a good faith routine operation, or like we talked about earlier, if it was done intentionally. And the court will also consider, which I think is important, the party's resources and technical sophistication. So we deal a lot with pro-pers, or people that represent themselves, and I think that's kind of true generally in a lot of like the enforcement, anytime the association's doing the suing, I feel like the other party very rarely lawyers up, depending on the type of case, but the court will look at that party's resources versus the association's, arguably resources, and kind of do a balancing act and say, well, you guys have an office of managers and, people to look for your stuff, or they're just one person. So that could really come back to bite the association and kind of weigh against the association if this person's really hiding the ball and not producing everything they should be producing. That definitely makes it a little bit more difficult. And then continuing on with Rule 37, if ESI that should have been preserved is lost, what are the remedies and the sanctions for the parties? So we talked about earlier that a court might allow additional discovery to restore or replace the lost information. So that was kind of my example of someone being copied on an email, where usually, that person is not really a relevant person to be talking to, but now they are, because they might be able to provide the information in a different way that's not available anymore. Otherwise, if the information can't be replaced, it can't be restored, and the court finds that the party acted with the intent to deprive the other party of the information, the court might presume that the lost information was unfavorable to the party. So they'll just tell the jury, hey jury, you can presume, because we don't have it, but you can presume that this email, was curse-filled and negative and really bad for that party, because they don't have it and they can't find it, and now you get to presume otherwise. You just kind of assume what the other side is saying is true. And the other thing a court can do, if it's really serious, is dismiss the action or grant the relief that the requesting party is asking for. It's a very serious matter of spoliation of evidence. There's other rules that I listed in your materials that govern, in a lawsuit, that govern the procedure for resolving disputes in court, which is just very specific procedures now with what steps we have to follow. Involves the parties filing a joint statement, and then the court might set a hearing, or they might rule just on that joint statement. There's very strict page requirements. That's how I know that the court was just like, enough. We don't want 20-page briefs on your discovery dispute. I think it's like a 3-page max joint statement on what the issue is, and leave it at that, and we'll take it from there. So it's kind of interesting to see how the courts are dealing with all of these specific issues. And there's also rules now in Rule 26 that allow parties and non-parties to seek protection from what they have to turn over. So I think it's trying to balance the need for turning over what's relevant, but not using it as a tool for harassment and bothering people and saying, okay, well, we'll take all your thousands of emails, please, and we'll take them tomorrow. So there's different steps that parties and individuals can take as far as protecting themselves from being annoyed or embarrassed or oppressed with the burden of having to go through and turn over all whatever information that the other party is asking for. And then there's also Rule 45.2, which is called the Safe Harbor Rule. And that just says a party or non-party who complies with a preservation order or letter is deemed to have taken reasonable steps to preserve ESI. So that kind of circles back to the importance of that. Once you get that preservation letter, whatever it's saying to preserve, definitely take the steps to do that, because if you can demonstrate that you took affirmative steps and you did everything, you dotted your I's and crossed your T's as far as the electronic storage of information, the court will definitely look at you a little bit more favorably than if you just kind of didn't delete everything, but just kind of sat on your hands. The court definitely won't like that. So that brings us to our last topic of why should boards or managers care about all of the stuff that I just said. And like we talked about earlier, most everything is done and stored on computers. And you guys have already kind of talked about how you personally deal with the fact that everything's done and stored on your phone now, and your computers and your laptops and all of that. If you're involved in litigation, e-discovery is almost certainly going to come into play. And that's just kind of how it is, that's how it is. So we kind of put together a few tips and then a disclaimer to our tips on how boards and managers can deal with this. We had definitely already talked about this first one, so you guys get a gold star for that one. Keep your emails and communications organized or separated, whether it's a separate phone, a separate work laptop, a separate email. Keep it organized so that if one of us comes to you, in a year and says, okay, well, we got sued and we need to turn over everything that's relevant, you can say, yep, I have that in this folder in my email. I know right where it is, or I know that that's in this email, not this email. That will save you time, and it'll help us be able to tell the other side where they can find information, where it's stored, who has it. So be mindful. That's step number 2. Be mindful of what you're saying in communications, because it could become an exhibit. Be mindful about who you're including on emails. As just kind of a general reminder, directors should not be, I've had this happen before where husband and wife is on the board, husband is not, but they share the same email. That is not keeping your stuff separate or watching, who's on what email, because really when you're sending an email to that email address, are you sending it to her, are you sending it to him? It gets really kind of messy, and messy in litigation makes litigation more expensive. So that's definitely not a good thing to do. You also don't really want to be super, it's hard to turn over your emails when you've said very disparaging things about that person or whatever, that situation. We've had, it's just embarrassing. So kind of keep that in mind. If you want to type out an angry email and then send it to yourself instead of sending it to whoever you wanted to send it to, that might be a better idea. But also, this is something that kind of trips us up a lot. I see it happening over and over, and I'm like, I think we can all do a little bit better at this, is long email chains, where we're talking about 5 different cases, but then after a while we're only talking about the 2 cases. I think it really would be cleaner to start a new email with that owner or lot number or contractor, vendor, whoever we're talking about, and start over there so that the whole email chain where we're talking about 9 or 10 other things, and then, oh, by the way, I heard from so-and-so, well, now so-and-so, we're suing them, and we have to turn this email over because we're talking about so-and-so, but also 7 or 8 other things, which aren't relevant, but this piece of it is relevant. So we need to kind of either redact what's not relevant or try in some way to agree with the other side how we're going to turn that information over. So I think that's something that's easy to do. I know that it's kind of nice to have like everything that you've been talking about in one email, but I think it would be neater to have have a clear subject line and to have the content of the email really truly be what your subject line is about. So I've been trying to do that a little bit more in emails that I send. And then the last tip is to put a records retention policy in place and follow it. Does anyone have a records retention policy for any of their communities? Do you guys know off the top of your head? It's
Never
not
heard of
something,
one.
yeah, and it's not something that a lot of people ask us for. But it is kind of nice to have something to fall back on. And we have samples of them too. I didn't bring any here, which would have been a good idea, but I do have cards in the back if you want to take one and shoot me an email. I can just send you a sample of what it looks like. But it just kind of dictates, here's the, what we consider association records, and here's generally how long the association retains its records for. And, there's different statutes, like, for example, the removal statutes in Arizona say that after the removal, so, you get your petition and you do your special meeting, so you have your ballots and, yes, that person was removed. So you have all those documents related to that removal. The statute says that those need to be held onto for 1 year. Whereas not, so you can, if you want to, you can technically get rid of that after 1 year, whereas you want to hang on to, you can't get rid of your meeting minutes after. Okay, that was 2017, we're over that, we get rid of your, just completely destroy your 2017 meeting minutes. So there's different requirements. You can hang on to things for however long really the board wants you to hang on to things for, but then there's also different statutes that say how long you have to keep things for. But then have that in place just kind of as a general guideline, but then also follow it and keep up with it so that if the court asks you, it's like, well, that's our policy. We follow our policy. Just as a matter of course, that's what we do. Of course, we have a disclaimer with that. If you received a preservation letter, you can't, like we said earlier, you can't just be like, la 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 la, that's what our policy says, 1 year, and did we receive a preservation letter about the removal? Okay, like, we don't care. That would get you in trouble. But if your documents were destroyed per the policy and you didn't get a preservation letter, you won't be sanctioned for destroying whatever it was per your policy. Yes.
You just touched on the meeting minutes.
Yes.
We electronically record our meetings.
Okay, like audio.
Audio.
Okay.
So it's in the computer. Previously, we used cassette tapes, and after a year,
Okay.
So what would be a normal amount of time to hold those? Because that's not the official. We then create the minutes, and those are then created and signed off on. The minutes are a synopsis of what happened, not the exact word for word translation. So.
Yeah. I think generally for anything that the association is doing, so something like that, my recommendation is always 6 years because that's the statute of limitations for breach of contract. So if someone's going to sue the board for a decision they made 3 years ago and we need the 2016 or 2015 meeting minutes, that's still within the statute of limitations. So my minimum is 6 years.
But technically, that's not the official minutes. That's
right.
Just the recording of the meeting.
Yeah. And that's why I'm not mad if you destroy them every year, but to be safe, because if you want to know the official record of the association, that's the typed in.
I want to see the minutes from the meeting. We hand them the official, approved, signed off, approved minutes.
And I think that's right.
We don't give access to the recordings of
unless
the
they
meeting.
request it.
We haven't been sued for that.
Yeah,
so.
sure, yeah. And it's kind of interesting too because the statute changed last year to say that if the association records the audio or video records the meetings of the board or meeting of the members, that should be provided upon request unaltered. But it doesn't.
That did go.
That's it. Yeah, that did go through. But that statute doesn't say how long that should be kept for. So it's really unaddressed, and if someone came asking for your minutes from for your recording last year, and you guys, it's known that you record them or videotape them or however it's done, and they request them, they would be entitled to them. But there really is no, it's not in the statute that came out last year, how long you have to keep those for. So it's really kind of an up in the air question right now. And that's why having a policy in place to determine some of that stuff, whatever the board thinks is reasonable, is kind of the rule of thumb. My suggestion, just on a conservative side, would be 6 years for the statute of limitations reasons that I said.
Well, it's much easier
but-
now that it's digitally.
Right, and it, you just store them, it's not bulky, you don't have to keep the actual tapes anywhere, but, so I think that's why a lot of boards don't really think about this, because they're like, well, it's on a computer, and it's not taking up the actual space, and it's, it's in the cloud, and it's fine. But if they wanted to have specific policies in place for something like that, so that they have something to point to if it gets them in hot water for some reason in the future, I think that would be the thing to do. And then again, what's the standard? It's just a reasonableness standard. So I would not say keep it for, keep maize until June. I don't think that's reasonable, but, keep it a year. Keep it, I think the safe conservative thing is 6 years. Keep it however long they feel comfortable keeping it. And that way they have a little bit something to fall back on as well. If someone says, well, why'd you destroy it? Well, that's what our policy says. And, there's nothing contrary to the law that says, for these kinds of tapes, you can't destroy them. When do you destroy them? There's nothing that really spells that out for you.
Nothing spells out how long it must be kept.
Correct.
It's just reasonable.
Yeah, kind of reasonable. What kind of a gut feeling kind of thing.
Okay.
So.
Did you say it's 6 years is the,
6 years,
statute of
yeah, the statute of
limitations?
limitations for breach of contract. So if someone was going to sue the board for breaching the CCNRs for approving X project or whatever, that they would have 6 years from the date that decision was made forward, or backwards. Yeah. Any other questions? I know it was kind of a lot, it was kind of legal and kind of boring, but I think you guys, it sounds like you guys are on the right track, and I think that's really encouraging. Hopefully this gave you some other things to think about, and some stuff that you can take back to your offices.